Welcome to Module 1 on U.S. copyright law. Intellectual property in general refers to creations of the mind like inventions, literary or artistic works, designs and symbols, names, images that are used in commerce. Intellectual property is protected in law by patents, copyrights, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. A copyright is an exclusive legal right that protects intellectual creations from unauthorized use. The U.S. adopted its first copyright law in 1790. They adopted the Copyright Revision Act of 1976, and in 1998 they amended the act to allow the U.S. to join the Berne Convention, which was a global treaty among many countries and did away with a lot of the formalities of copyright law. The 1976 Act, as amended, specifies what may be protected by copyright. It was almost immediately outdated. It did not foresee the personal computer, the internet, MP3 players, satellite TV, and radio, and other developments. Copyright law protects original works of authorship that are fixed in a tangible medium of expression. Authorship includes authors, composers, journalists, sculptors, and others. The law does not define what is original. It basically means a work independently created by its author and not one copied from pre-existing works, and a work that comes from a creative mind. A collection of previously created works can be protected if there's originality in how the work is arranged. A work must also be fixed in a tangible medium. It has to be capable of being seen, reproduced, or communicated. This could include music on a CD, a quilt, a marble statue, images on video, or words on paper. The federal statute lists a variety of items that can be copyrighted, but this is a list that's just illustrative. It includes the following: literary works, which also includes computer software; musical works, including any accompanying words; dramatic works, including accompanying music; pantomimes and choreographic works; pictorial, graphic, and sculptural works; motion pictures and other audiovisual works; sound recordings, and architectural works. Copyright law is a little bit more specific about what cannot be copyrighted. Trivial materials cannot be copyrighted. Things like titles, slogans, and minor variations on works in the public domain are not protected. Ideas are not copyrightable. The law protects literary or dramatic expression of an idea, such as a script, but doesn't protect the idea itself. It has to be expressed in a tangible medium. Utilitarian goods, things that exist to produce other things. A lamp, for example, is a utilitarian object that exists to produce light. One can't copyright the basic design of a lamp that makes it work, but the design of a particular element that is separate from the useful article can be protected, such as the unique stained glass effects of a Tiffany lamp. Methods, systems, and mathematical principles, formulas, and equations cannot be copyrighted. I can't claim copyright of 2 + 2 = 4. But a description, an explanation, or an illustration of an idea or system can be copyrighted. So if I wrote a math book, the arrangement of the principles and the formulas and the way I explain those can be copyrighted. When news is reported correctly, it's basically an account of facts. So can a news account be copyrighted? Well, suppose a TV reporter gets an exclusive interview with a really reclusive public figure and then broadcasts the interview on the evening news. Does the law of copyright prevent other journalists from relating the substance of what was revealed in the interview? The answer is no, but other stations cannot replay the same interview without permission. Newspapers can't publish a transcript of the interview, but both broadcast and print journalists can tell their viewers and readers what the public figure said in the interview. Copyright law doesn't even require the competitors to credit the TV journalist for the interview. Failing to give proper credit is grossly unethical, but it does happen. Charges of plagiarism could be made and a lawsuit filed. Copyright law protects the expression of the story, the way it is told, the style and the manner in which the facts are presented, but not the facts themselves. An original work is automatically copyrighted from the moment it is created and fixed in a tangible medium. The copyright must be registered, however, before the creator may sue for copyright infringement. A work's creator owns the copyright, typically. When a person creates a work as part of his or her employment, the law typically gives the copyright to the employer. This is called a work made for hire. Under most circumstances, freelance journalists, for example, own copyrights to their work. Copyright law allows copyright ownership to be changed by contract. A magazine may agree to purchase a story written by a freelance journalist only if the journalist agrees to transfer the copyright to the magazine. The law of copyright gives the author or the owner of the copyright the sole and exclusive right to reproduce the work in any form for any reason. There are actually 6 exclusive rights recognized under the law. These rights are reproduction of the work, preparation of what are called derivative works. So if I wrote the play, I should also be able to write the screenplay. The right of public distribution of the work, public performance of the work, public display of the work, and public digital performance of a sound recording. Some protections are not absolute under U.S. copyright law. For example, although the law says that only the creator may copy his or her work, the Supreme Court has held that individuals may make a copy of TV programs for their own use. The same principle of making a copy of a recording is basically allowed because it's the idea of the VCR. This really came into question when the VCR started to be used. Making a copy of a recording for your own use is allowed and is not a copyright infringement. Copyright owners don't have the right to control individual copies of their work after distribution, with a few exceptions, of course. A person who buys a copy of a novel may give away that book. They can sell it, they can rent it, they can throw it away. This is called the first sale doctrine. Once creators have distributed copies of their work, they no longer can regulate what happens to those copies. While you can transfer the physical object containing the copyrighted work, you don't transfer any rights in the work. For example, if you give someone a book, you're not giving someone the right to create a derivative work from that book, such as a screenplay. Congress did limit the first sale doctrine. They restricted rentals of recordings without the copyright holder's permission. The law also forbids renting computer software. How long does a copyright last? Well, the length of time that a copyright will protect a given work really depends on when the work was created. Any work that was created after January 1st of 1978 will get the life of the creator plus 70 years. A work that's been created by 2 or more authors extends through the life of the last author to die plus 70 years. What's called a work for hire is protected for 95 years after the date of publication. Works for hire include books written by an author for a publisher, which then holds the copyright. Also included are motion pictures, sound recordings, TV programs, and things that are created through a collaborative effort. Works created before January 1st of 1978 are protected for a total of 95 years. A copyright doesn't necessarily disappear when someone dies. The holder can actually transfer the right to someone else through a will. Before a copyright holder can sue for infringement, the copyrighted work must be registered with the federal government. To register a work, the author or owner must do 3 things. Fill out the proper registration form. Pay a certain fee, which is usually a lower fee if you register online, and the fee goes up if you actually do a mail-in through snail mail. Then you deposit 2 complete copies of the work with the Copyright Office. The statute gives an author or owner 90 days to register a work. Well, what happens if the work is still not registered after 90 days and an infringement takes place? Well, the owner can still register the work and bring suit, but a successful plaintiff in such a suit cannot win statutory damages or compensation for attorney's fees. There are some other damages they can get, but they can't get those too. It's best to get into the habit of registering a work as soon as it is published or broadcast. To sue for infringement, you must first show proof of a copyright. The copyright, again, has to be registered. If the copyright holder can prove direct copying, he or she can win the suit if the defendant has no effective defense. More likely, the plaintiff will attempt to show that the infringer had access to the copyrighted work and the two works are substantially similar. You have to show a reasonable probability of access. You don't have to show the infringement was deliberate. Accidental infringement is still a violation. Plaintiffs in a copyright suit can ask the court to assess the defendant for any damages they've suffered, plus the profits made by the infringer from pirating the protected work. In each case, the plaintiff has to prove to the court the amount of the loss or the amount of the defendant's profit. Rather than prove actual damage, the plaintiff can ask the court to assess what are called statutory damages, or damage amounts prescribed by the statute. A judge can also restrain a defendant from continued infringement through an injunction. They can impound the material that contains the infringement. They can order the destruction of these works. The government can bring criminal charges for copyright infringement even if the infringer did not make a profit through the No Electronic Theft Act. A person sued for copyright infringement might claim that the plaintiff did not file within the law's 3-year statute of limitations or 5 years for criminal charges. Or a defendant might argue that the copyright holder knowingly abandoned the copyright, placing the work in the public domain. The most common defense, though, is fair use. What if an English teacher copies a few paragraphs from a novel for class discussion, or a movie reviewer shows 15 seconds of a film on TV to illustrate a point about the movie, or a comedian sings a portion of song lyrics in parody? Courts have long said these are fair to the copyright holder and to society. To determine if a particular use of a work is fair use, the courts will look at 4 factors. First, what is the purpose and character of the use? The purpose and character of the use of a work is the initial factor they look at. A use is more likely to be considered fair use if it's for a non-commercial or non-profit use. The law lists several categories of use that may be protected by fair use, like criticism and comment, teaching and scholarship and research. Just because a use falls into one of those categories doesn't necessarily mean a fair use defense will automatically be successful. At the same time, uses that fall outside of these categories may still qualify as a fair use. Secondly, they look at the nature of the copyrighted work. They'll look at several considerations when applying this criterion. The nature of the copyrighted work. Is the work still available? Using part of a work that's out of print is far less serious than using a segment of a book that can be readily purchased at the local bookstore. Is the copyrighted work what's called a consumable work? Something that's intended to be used just once, like a workbook that accompanies a textbook. This wouldn't be fair use for a teacher to purchase a single copy of a workbook and then make photocopies for all of the students and pass them out. Is the work informational or creative? More likely to be fair use if the copying involves a work like a newspaper or news magazine or encyclopedia, rather than a novel or a play or a poem, something that might be viewed as a little bit more creative. Is the work published or unpublished? The author's right of first publication is regarded as a valuable right by most courts. The third element of fair use is the amount and substantiality of the portion that's used in relation to the copyrighted work as a whole. The amount of a work used is not as important as the relative proportion of the work. Word counts, for example, don't really mean as much as percentages. Courts will consider exact copying, when looking at this question, but they'll also often consider paraphrasing. Finally, the effect of the use on the potential market for or value of the copyrighted work. This is probably the criterion that's given greater weight by most courts than any of the other three. What is the potential harm to the plaintiff? In a Congressional Committee report on the 1976 copyright law, the legislators noted that, with certain special exceptions, a use that supplants any part of the normal market for copyrighted work would ordinarily be considered an infringement. The inability of the plaintiff to demonstrate an adverse economic impact from the copying can usually in and of itself sustain a fair use ruling. In evaluating economic impact, the court will consider not only direct impact, but also the impact of using the copyrighted material that the impact might have on some derivative creation. Imagine, for example, a screenwriter, Virginia Miller, uses a Stephen King novel as the basis of a screenplay she prepares. The screenplay contains a great deal of material from the book. Not many screenplays are sold on the retail market. But clearly, should Miller sell her screenplay to a motion picture producer, this action would deprive King of the likelihood that he could sell his own screenplay based on the novel. King would lose a derivative right of an author to market a creation derived from the original work. In 1998, the Digital Millennium Copyright Act was adopted by Congress in an attempt to bring the Internet and other digital media into the copyright law. The DMCA bans software and hardware that facilitates circumventing copyright protection technology, with, again, certain exceptions. For example, the Act forbids software that would disable anti-copying features in a DVD player, or software enabling DVDs to be copied. The DMCA also prohibits removing or changing copyright information, such as the copyright owner's name. The law shields Internet Service Providers, or ISPs, and video sharing sites from copyright infringement claims if an ISP removes material that a copyright holder tells the website is posted without their permission. This is called a takedown notice. Because copyright protects compositions, permission is needed to use them. Composers have the right to limit public performances of their works. Music licensing organizations represent music publishers and composers. Groups such as ASCAP, BMI, and CSAC grant licenses to people, groups, and businesses that permit performance of copyrighted songs for specific purposes. The groups collect fees from the song users, and these fees can be a few $100s annually for a small bar that hosts live musicians to millions of dollars for a major broadcast TV network. The fees are distributed semi-annually to music publishers and composers based on how often their songs are played. Not everyone is part of a licensing organization. At one time, for example, Sony ATV held the music for Lady Gaga, Michael Jackson, and Taylor Swift and had to be negotiated with directly. When Napster first allowed one computer user to reach into another computer to retrieve files containing copyright music, and individuals used this peer-to-peer network to make unauthorized copies, a federal appellate court agreed with the recording industry that Napster's operation violated copyright law. A Boston University graduate student had to pay $675,000 in damages for illegally downloading and sharing 30 songs. Now, I'd like to close out with showing a couple of examples from the music industry on some copyright cases. First, I want us to listen to a version of George Harrison's My Sweet Lord. We'll just listen to a little bit of it and compare it with a song from the Chiffons. George Harrison's My Sweet Lord was released in January of 1971, and it hit the charts as his first solo single. It was released under the Apple label and enjoyed the #1 spot for about 5 weeks, and then again in 2002 for 1 week after George's death. It remained on the charts for a total of 27 weeks. Now, all of this is great news. The not so good news involves a song called He's So Fine, that had been recorded by the Chiffons about 9 years earlier, and then moved under the Bright Tunes Music Corporation label in 1971. The Chiffons song did well in the United States, and it received a lukewarm reception in the UK. February 10th of 1971, Bright Tunes filed a suit against George Harrison. The suit included Apple Records, BMI, and Hanson Publications. So let's play a little bit of this, and then I'll tell you how the suit ended. Okay, so there's a little bit of George. Now let's hear a little bit from the Chiffons. This was the song again that came out about 9 years before George's song.
He's so fine. Wish she were mine. That handsome boy over there. One with the wavy hair. I don't know how I'm gonna do it, but I'm gonna make it mine. Be the envy of other girls. It's just a matter of time. He's a soft-spoken guy.
Okay, so you get the idea. Now let's hear kind of a mashup and analysis of these two songs together.
Here's Harrison's My Sweet Lord.
My sweet Lord, my Lord.
And here's He's So Fine by the Chiffons.
He's so fine. Wish she were mine.
Obviously, they're not identical. They feature different tonalities, tempos, structures, instrumentation, and musical character, but they are very similar. Even though they're in different keys, the chords and melodies are nearly the same. And if we take a few liberties with tempo and tonality, we can play them simultaneously to illustrate the resemblance.
He's so fine. Wish she were mine. And handsome boy over there. One my wavy hair. I don't know how he wanna do it, but I'm really looking through it.
Now, some students that I've had listen to this can really hear the similarities, and others have a little bit more difficulty. But here's what the court said, basically. They tried to reach an out-of-court settlement, but it never came to fruition before the court case proceeded. And the case waited to be heard for 5 years. Well, finally, when it was heard in 1976, the judge found that although he didn't think that George purposefully plagiarized the song, the two songs were essentially the same, with just a few minor differences to note and chord. And he was found guilty of something called subconscious plagiarism, and he had to pay $587,000, and the judgment was dismissed after he paid it by 1981. But again, it wasn't intentional. They felt like maybe George had heard the song years before, and it just kind of was rattling around in his brain, and he didn't realize he was copying, but essentially he did. And then, of course, I have one last example to show you, and this is from the 1990s.
VIP. Let's kick it. Ice, ice, baby. Ice, ice. I sit back with my friend with benches. Then, felt a hold of me tightly, flow like a hawk, daily and nightly. Will it ever stop? Yo, I don't know. Turn off the lights, and I'll go.
Okay, I don't know about you, but I can't take any more. Vanilla Ice became a household name for a while, but this copyright infringement that occurred in 1990, that he had sampled Queen and David Bowie's song Under Pressure without consent or license, really put him on the hot seat. Ice Ice Baby hit #1 on the charts in the US, and Vanilla Ice said he thought he had complete license to use the song. He had not asked for permission from Queen or David Bowie. He said, I altered the rhythm of the bass line slightly, and he thought that would allow him to avoid any question of credit or royalties or permission. Well, the case never went to court, as it was clear that Vanilla Ice had stolen the sample without permission, and he settled out of court with Queen and David Bowie for an undisclosed but very likely high amount. Ice Ice Baby has been released many different versions since then, but rest assured all of the legal procedures have been followed.